Welcome to our program today. Today we're going to be talking about the new no surprise billing rules. My name is Kim Stanger. I'm the head of Holland Hearts Healthcare Group, and we typically provide these webinars free of charge to our clients and others who may need to know about important issues that have been coming up. And it's been quite a year. The last couple of years have been quite a time for healthcare, both with the pandemic as well as additional regulations. As part of the materials that we provided, you should have received a link that would allow you to access a copy of the PowerPoint slides along with some written materials that we've made available, including the interim final rule. If you did not receive those, shoot me an email, or you can check with Charles Cobbins. I've forwarded his contact information in the chat feature. In addition to the actual interim final rule and the commentary, there's a few documents that CMS has produced that are helpful in helping to understand the new rule. Also, the AHA has published a good summary of the No Surprises Act, and I've given you the links to that. That gives you a bit of background, both for the context for these new rules, as well as other issues that may be coming down the pipe. In general, the No Surprises Act and the new rules were meant to address the following problem, where patients are surprised when they receive a bill from a facility or provider, even though they thought that they had insurance. Particularly, the government was concerned about two particular cases. One is where the emergency services are rendered by a non-participating, or for purposes of our conversation today, a non-par facility or provider. So the patient has to go there. They don't realize that that facility is not a participating provider, and suddenly they get hit with a huge bill that they weren't anticipating, or more than they thought that they would get. The government was also concerned where non-participating providers at a participating facility bill separately from the facility. For example, surgeons, anesthesiologists, radiologists, pathologists, those types of situations. The patient suddenly and unexpectedly learns that they have a bigger bill than they thought they were going to have because of all of these other people that they really didn't have a choice in receiving services from, that they get this bill from these non-participating providers. Consequently, as a result of that, the government came out with the No Surprises Act. That's actually the statute that was passed last December. In July, we received the first installment of the rules implementing the statutory requirements. It's the No Surprises Interim Final Rule. It issued July 13th, 2021. That interim final rule protects patients, beneficiaries, and enrollees in health plans and insurance. For purposes of today, I'm just going to refer to them as patients or insured patients. It protects those insured patients from surprise medical bills by limiting the amount that the patient must pay out of pocket to in-network amounts. So it limits you as providers, you can't charge more than the in-network amounts for certain services. It's important to note that these new rules only apply in these circumstances. They only apply if there are emergency services that were provided at an emergency facility, for certain non-emergency services provided by a non-participating provider at a participating facility, or air ambulance services from a non-participating provider. In those cases, in those situations, the rule limits your ability to charge more than the in-network rates to the patients for those services and prevents you from balance billing the difference to the patients. In addition, all such payments, all cost sharing that the patient makes, count toward in-network deductibles and out-of-pocket maximums. These new rules take effect for providers effective January 1st, 2022. Well, what happens if you violate these rules? Well, under the No Surprises Act, you can get hit with a fine of $10,000 against facilities and providers who violate the rules. The Act at least provides that there are ways that HHS can mitigate or waive the penalties in certain circumstances, but we don't have the enforcement rule yet. This is part of the rules that we need to watch for that may be coming down between now and January 1st. So make sure that you watch for those so that we get more information concerning the future rules. There's pros and cons, obviously, to the new rule. It's not just all cons. There are some pros for some benefits to healthcare providers, kind of. Among other things, it reinforced patients' ability to choose their provider for pediatric and OB/GYN care, so that they can designate one of those as their primary provider if they want. That was already in the rule, or in the provisions under the ACA, but they extended it under this proposed rule, or under this interim final rule. In addition, plans must cover out-of-network emergency services on an in-network basis without prior authorization. Now, that was required by the ACA already. It required those plans and insurers that were covered by the ACA to cover emergency services, but the new interim rule expands that to other entities that weren't required to do that in the past. In addition, the new rule established a process for determining the rates that are going to be paid to out-of-network providers. If you're an out-of-network provider, you may not like the new rate, but at least there's a process for determining what that rate is. It also requires the plans to deny or make an initial payment. And by initial payment, we don't mean that it's just a lowball payment. Instead, it needs to be a good faith estimate of their payment in full. They've got to they've either got to deny the claim or make that good faith payment in full within 30 days after the provider submits a clean claim. If the provider disagrees with the amount that is submitted, then there's a process under the interim final rule for handling payment disputes between the provider and the plan. So you may not like exactly the amounts, but at least it sets forth a structure for dealing with insurance companies on getting paid in these types of situations. Now, the downside, of course, is for you who are out-of-network providers and you're used to simply balance billing the patient or charging arguably higher rates to insurers, then you may have limits, particularly with regard to the cost-sharing limits. The new rule provides that it limits the patient's cost-sharing amount to that which the patient would owe to a participating provider. That is, you can't balance bill beyond the approved cost-sharing amount unless the non-participating provider obtains the required notice and consent from the patient. Now, that notice and consent, the downside with the notice and consent is that it only applies in certain limited circumstances, and the burdens are so onerous that, quite frankly, I don't know why any patient would ever consent to be being billed more than they otherwise are obligated to pay. We'll talk about that more in just a minute. In addition, providers and facilities must publish a public notice of these patient protections to the patients effective January 1st, 2022. We'll talk about that in just a minute. So let's talk about those limits on the patient's cost-sharing amount. The patient's cost-sharing for out-of-network services, if you fit within one of those three situations, right? If you fit within the situation for emergency services that are provided by a non-participating provider or a non-participating facility, or certain non-emergency services that are provided at a participating facility by a non-participating provider, or air ambulance services provided by a non-participating provider. In those situations, those entities, those providers, are limited in the amount that they can charge the patient for cost sharing for out-of-network services. They're limited that they can only charge basically the in-network rates for those cost sharing amounts. So for example, if a patient's cost sharing amount for in-network services is 20%, then the patient's cost sharing amount for the out-of-network services is also going to be 20%. Now, in determining the amount to which the cost sharing portion applies, that's defined as the recognized amount. And that recognized amount is determined in the descending order of priority. So the regulations tells us how you can establish what that recommended amount is. That amount is necessary to determine what the patient's cost sharing amount is. So first, you would look to see whether the state has an all-payer model agreement that's established under the Social Security Act. There's only 2 states that have that. Probably doesn't apply to you. If there's no all-payer model agreement in your state, then you would have to look to see whether or not your particular state law has limits or a process for determining the amount that you can charge patients under these circumstances. There's about 15 to 17 states that apply that. If the state has that rule, then you go with that. Otherwise, for most of you, you're going to drop down into this next category. If neither of those foregoing apply, the lesser, then you're limited in charging, or the cost sharing amount is going to be based on the lesser amount of either the billed charge, the amount that the non-participating provider actually bills, or the qualifying payment amount, the QPA. This is a new term. That QPA is generally the plan's median, or plans or insurance companies, insurance policies median contracted rate as set forth in their 2019 arrangements for the same or similar services provided by a similar provider in the same geographic region, adjusted by a consumer price index. So if it's a situation where a non-participating provider wants to balance bill the patient, then they would have to presumably check with the insurer to determine what the amount is that they can balance bill so that they don't violate the billing rule. And they would have to get from the insurer that QPA. As part of the information that the insurance company has to provide to the provider, they've got to provide what that QPA amount is back to the provider. Now remember that these limits on the patient's cost sharing amount only apply to certain items or services that are otherwise covered under a health plan or insurance that is provided by a non-participating provider and or non-participating facility to the patients. So it only applies if the plan otherwise provides coverage for these services. These limits don't apply if the plan simply doesn't provide coverage for these services. That's outside the scope of the no surprise billing rule, and you wouldn't have to comply with these requirements. It only applies if there is coverage for the benefits, and then it determines the amount that you can charge the patient for those covered services. Now, it applies to almost all health, the benefits that are offered by almost all health insurance plans or self-insured plans and the like. So it extends beyond the ACA to entities that weren't otherwise covered by the ACA. There are a few plans that are excluded from these requirements, but they're very limited. Generally, they're just accounts like health reimbursement accounts, and those. For most of you, it's going to be all of your insurance companies are going to apply. Obviously, these don't apply to government payers like Medicare or Medicaid because they've already got their limits on your ability to balance bill in the statutes and regulations, so they're not covered by the no surprise billing rule. The limits on these patients' cost sharing amounts, the no surprise billing rule, the limits on balance billing only apply to in certain circumstances, as I mentioned. It only applies to non-participating providers or facilities if the provider or the billing facility, if they are participating in the plan, then they don't need to be covered by this because they're limited by the amounts that they can bill by the plan documents. So this only applies to non-participating providers or non-participating facilities. And it only applies to, again, certain circumstances. It only applies to emergency services that are provided by a non-participating provider or a non-participating emergency facility. So the first one is the emergency services exception or the emergency services provision. That only applies to these services at emergency facilities. Emergency facilities are defined under the regulations as an emergency department of a hospital or an independent freestanding emergency department to the extent that such are licensed by the state. If the state licenses urgent care centers as a freestanding, independent freestanding emergency department, then it would also apply to those urgent care centers. It would not apply to emergency services or quasi-emergency services that are provided at other entities that are not an emergency department of a hospital or an independent freestanding emergency department. The second situation in which these rules apply are non-emergency services that are provided by a non-participating provider at a participating healthcare facility. For this situation, healthcare facility is defined as a hospital outpatient department, critical access hospital, or ASC that has a contract with a health plan covering the services provided, including single case agreements. So these no surprise billing rules do not apply to all healthcare providers in all settings. It only applies to those non-participating providers or non-participating facilities, and it only applies to the extent that they are providing services in connection with a visit to a facility. For emergency facilities, emergency services, then it would apply to hospital emergency department or these freestanding emergency departments. For non-emergency services, the no surprise rules are only going to apply if the non-participating provider is rendering covered services, otherwise covered services, at a participating healthcare facility, a hospital outpatient department, critical access hospital, or ASC. If you are providing services outside of those facilities or not in connection with one of those facilities, then these rules do not apply to you, at least in that particular situation. Just note, well, I'll come to that in just a minute. It also applies to air ambulance services that are furnished by a non-participating provider of air ambulance services. So that talks about the total cost sharing amount that the patient must pay, the limits on that. The rule also addresses the situation, well, how much does the insurance company or the plan have to pay? Under the new rule, then the total amount paid to a non-participating provider or non-participating facility, including any patient cost sharing amount, is based on the following. And again, there's this hierarchy. So to determine the amount that the insurer plan has to pay the non-participating provider or facility for those situations that we talked about, right? It only applies in the emergency services case or in the case of a non-participating provider at a participating facility or a non-participating air ambulance provider. So it only applies in those situations. So if we're talking about the amount that those non-participating providers get, then you would look to the amount determined by the applicable all-payer model. Again, that's not going to apply in 48 of the states. If there's no applicable all-payer model, you would look at the particular state law. If there's no state law that governs this, again, that's only probably 15 to 17 states have those laws, so that's not most of you. If there's neither of those apply, then you would look to the amount that's agreed upon by the plan, provider, or facility. So if you can agree with the provider or the plan as to what should be paid, then that's the amount that you would go with. If there is a dispute concerning the amount that you are going to pay, then the statute and the rule sets up a process. If the plan and provider cannot agree on the charge, then the amount is determined by an independent dispute resolution process through a separate entity. We do not have the rules yet for that IDR process. We don't have the regulations. The No Surprises Act did kind of give us the outline for it. In general, the Act states that after that claim is, or the dispute is indicated, that the parties believe that there's a dispute, they have 30 days to attempt to reach an agreement. If they can't do that within that 30-day time period, then either party may initiate the IDR process, the independent dispute resolution process. In that IDR process, the plan or the insurer and the non-participating provider or facility each submit their own proposal for what they think that the appropriate rate is going to be. And then the IDR makes the determination of what the provider gets paid. Now, this isn't a situation where the IDR entity can split the baby, at least according to the Act. Instead, they go by the baseball arbitration rules, which is basically the IDR entity picks one or the other, either the amount that was recommended by the insurance company or the amount that was recommended by the provider. So they get to choose which one of those two they think is the most reasonable, and that's what they accept. The guidance that we've received, the Act sets forth certain issues that may be considered in making that determination. After considering those factors, the IDR entity determines which proposal is reasonable, and then that's what's going to be paid, and the loser has to pay the administrative costs. At least that's the way that it appears right now. Again, we need to watch for the regulations that are supposed to come out that are going to explain this process further. So if you're a provider, what's the net effect of this? Well, the net effect of it is that the patient is going to pay for those emergency services or non-emergency services provided in conjunction with a visit to a healthcare facility. Then the most the patient is going to have to pay for out-of-network services is the in-network rate for those services based on the recognized amount, which is generally going to be that QPA, or the contract median contracted rate for similar services and the providers. Now, that's separate apart from what the insurance company or plan must pay. The insurance plan or plan has to, the amount that they have to pay, again, is determined by those 4 factors. Generally, it's going to be either the agreed amount, or if they can't agree the amount, then the amount that's determined through that IDR process, less the patient's cost sharing amount. So the plan would only have to pay the amount that it owes, not for the patient's cost sharing amount. So in summary of the surprise billing rule, remember that it doesn't apply to everything. It only applies, in this screen up here, to those items that are covered by red. Everything else is outside the scope of the no surprise billing rule. It only applies, these limits on the patient charge only applies to cost sharing for non-participating providers. And the patient charge is going to be the same cost sharing amount that they would have as if the provider were participating. It's only going to apply to covered emergency services provided by a non-participating provider or non-participating facility, and covered non-emergency services by a non-participating provider at a participating facility. And it will also apply to air ambulance services provided by a non-participating provider. But there is an exception. In those situations where the rule would otherwise apply, there is an exception that allows you to balance bill despite the rule, so long as you notify the patient and obtain consent from the patient, and you notify the insurer. Okay, so there's a limited exception for certain circumstances. But that exception does not apply to certain services, including pre-stabilization services, emergency services, and certain urgent services that arose out of the actual provision of the services, and certain ancillary services. So let's talk about some of those rules now. Let's talk first about the situation where we're balance billing or want to balance bill for emergency services. If a covered patient receives emergency services at a hospital emergency department or an independent freestanding emergency department, the non-participating facility may not balance bill the patient above the cost sharing amount for a participating facility. Or in the case of a provider, a non-participating provider may not balance bill the patient above the cost sharing amount for a participating provider. The general rule is you can't balance bill above the in-network cost sharing amounts, except for certain post-stabilization items or services if you satisfy the certain criteria. So if you're providing emergency services, even though you're non-participating, general rule is you can't balance bill unless you satisfy the following criteria. If you're providing certain post-stabilization services, so after the patient's been stabilized in that emergency department, if you're providing certain post-stabilization items or services, then you can balance bill if you satisfy certain criteria. Specifically, the patient has to be able to travel to a participating facility within a reasonable distance in a non-medical transport. So they're only going to allow you to balance bill if the patient has a choice and the ability to transfer to a participating facility. Next, the patient has to be given the required written notice that alerts them to their rights. And then the patient has to agree to essentially waive those rights and agree to be balance billed for the services outside of the in-network rates. And the facility has to satisfy any additional state law requirements that may apply. Now, this emergency services exception, it only applies in those situations where a patient goes to an emergency department or a freestanding emergency department for emergency care. Emergency services are generally those services that would be covered by EMTALA if they went to an emergency department, right? So patient shows up there, they get the screening exam, they get stabilizing treatment. So they interpret that broadly. Sometimes the government was concerned about situations where a health plan or insurer would, after the fact, claim that certain emergency services really weren't emergent, and therefore they would refuse to provide coverage. And the government basically said in this new rule, no, that doesn't work. If a reasonable person would think that there's an emergency, so they go to the emergency department, then the insurer has to provide that coverage as if it was in network. So it applies to the services that are provided in response to that emergency condition. So the screening exam, the stabilizing treatment. In addition, they broadened it beyond EMTALA requirements a little bit to also include post-stabilization outpatient observation or inpatient or outpatient care after the emergency care is provided. So they've kind of extended those ACA requirements that otherwise required the plans to cover emergency services to certain post-stabilization emergency services also, so long as they're related or arise from that emergency visit. HHS interprets this new definition of emergency services relatively broadly to essentially track EMTALA standards. The services are covered even if the care turns out to be non-emergent. The services are covered even if the provider uses a non-emergent code, and the services are covered even if the care is not immediate. Now, for those emergency services situations, the general rule is you can get notice and consent and balance bill a patient if you get that notice and consent for most services, but there are certain circumstances that you can never balance bill the patient, even if you tried to get patient consent. For the emergency medical screening and stabilization services, you can never balance bill for that. Okay? So you're going to be stuck by the no balance billing rule. You're going to be stuck by the patient's cost sharing amount. In addition, if you're providing or you want to bill for items or services that are furnished as a result of unforeseen urgent medical needs that arise at the time an item or services is furnished, then in that situation also you can't balance bill for that. The reason there is it's true that the government has recognized that in certain circumstances you can give notice and consent to balance bill the patient, but if it's an urgent, emergent situation that arises while you're providing the care, then that patient really you can't give the patient notice and the chance to consider it and provide that consent, and therefore those exceptions to the balance billing rule do not apply. So you can never balance bill for those kind of urgent situations that arise while you're rendering the care. In addition, if you're providing those emergency services and you want to balance bill, you also have to notify the insurer and provide them with certain information to confirm that you satisfy the balance billing requirements. So that's the general rule for emergent services. What about balance billing for non-emergency services? Well, this applies in the situation where a non-participating provider provides non-emergency services to a patient at a facility, at a healthcare facility. Remember, that's like the hospital, the critical access hospital, the ASC, those entities. So if this non-participating provider is providing those non-emergency services at a facility that is participating, then they are limited in their ability to balance bill a patient above the applicable cost sharing amount unless they give the patient certain notice and the patient consents to allow them to balance bill outside or beyond the in-network amounts, except you can never balance bill for certain situations. So even if you have a situation where you have non-emergency services, you want to seek the patient's consent to balance bill the patient outside of the in-network rates, the government still says, well, you can't do that for these situations. You can't do it for ancillary services. And the ancillary services are those that are provided in conjunction with that visit at the facility, including items or services related to emergency medicine, anesthesiology, pathology, radiology, and neonatology, whether provided by a physician or a non-physician practitioner. So for example, if you've got a lab that's providing services to a patient in non-emergency services to a patient at a participating facility, that lab is a non-participating facility, then that lab cannot balance bill for those services that are related to that visit at that facility. The lab is limited to the cost sharing amounts that are set forth in the rule, even if the lab's off-site, because those services were related to that visit at that participating facility. The limits also apply to items or services that are provided by assistant surgeons, hospitalist intensivists, diagnostic services, including radiology and labs, and items or services provided by a non-participating provider if there is a participating provider who can furnish such item or services at the facility, or if the items or services are furnished as a result of unforeseen urgent medical needs that arise when the item or services is furnished. So in these situations, that consent and notice exception will not apply. You can simply, if you're one of these providers providing care and you're non-participating and you're providing these services in conjunction with services that are rendered at a visit to a healthcare facility, then you cannot bill for these services. You can't balance bill for these services. You're going to be limited by the amounts that are set forth in the no surprise billing rule. All right. So there are those limited circumstances where you can seek notice and consent from the patient that would allow you to balance bill. But those situations are relatively limited. In those situations, you've got to provide notice to the patient or the patient's personal representative. The personal representative is the entity that has the authority to make healthcare decisions for the patient under applicable state law. The notice you provide to them has to be written or electronic, and the patient gets to decide which form of notice they get. The notice must be provided using the HHS form. So HHS is preparing a form that you have to use in order to give this notice. That notice has to satisfy the requirements that are set forth in the regulation. So watch for that notice. In the case of balance billing or attempting to balance billing for post-stabilization emergency services, in addition to the other information that has to be contained in that notice, you need to also provide additional information to the patient before you can balance bill. If it's a situation where you have a participating facility but a non-participating provider, and this is again only in those situations for emergency services, you've got to also include a list of the participating providers at the facility who are able to furnish the services and state that the patient may be referred to the participating provider. So you basically got to tell them, hey, I'm not participating. If I bill for these services, you have the chance, you have the option to elect to come to me and I will bill outside the network and you'll have to pay me more money, or these are the other persons within the facility that are network and you can get in network and you can get the information, the services from them. If it's a non-participating emergency facility that wants to balance bill, then that non-participating emergency facility has to include in that notice a good faith estimate of the charges by the facility that are non-participating providers for the visit at the facility. That notice has to be provided within certain time frames and in a certain manner. It has to be provided with the consent document, but it has to be physically separate from any other document and not attached to any other document or incorporated into any other document. So it can't be like small print on other documents. It has to be a standalone document. It has to be provided to the patient in a timely manner, meaning that if that patient schedules the services at least 72 hours in advance of getting those services, you've got to provide that notice at least 72 hours before the services are provided to give the patient a chance to consider it. If the services are scheduled less than 72 hours in advance, then you've got to provide the notice at the time that the services are scheduled. If the notice is provided on the date of the service, then you've got to provide that notice at least 3 hours in advance of the services. If it's an emergency situation, you can't give that advance notice, then you just simply can't do the balance bill route. You can't give the notice or get the consent that you would otherwise need to get you out of the balance billing prohibition. In addition to providing the notice, you've got to get consent from the patient or the patient's personal representative. That consent has to be obtained voluntarily using HHS's form. So we'll have to watch for that consent form that HHS is sending out. And it has to be provided or obtained in accordance with the form and manner specified by the HHS guidance. The consent must be signed by the patient or the personal representative prior to receiving the relevant items or services. And the patient or the personal representative has the right to revoke that consent in writing prior to receiving the items or services. The consent has to contain certain elements. Again, the HHS consent form will have all of that information in it, but basically you got to make sure that the patient understands that by agreeing to this, they are waiving their rights that would, and basically exposing themselves to additional charges they would not otherwise have. You must provide a copy of this signed written notice and the consent to the patient or the person, either through email or mail as they request, so they're entitled to get a copy of that. That consent only applies to the receipt of information regarding the balance billing. So, for example, you have to put in there the reasonable expectation of charges. When you submit that, that consent is just consent to be charged above the cost sharing amount, but it's not necessarily a consent to be charged the amount that the provider wants to charge. It's not an agreement or a contract that that patient's going to pay that amount. When you get that notice and consent or provide that notice and consent, you've also got to comply with the HHS rules concerning language accessibility. So specifically in this rule, they confirm that the non-participating provider or facility must give the patient the choice to receive that notice and consent in any of the 15 most common languages in the locality of the entity. And if the patient's preferred language is not among the 15 most common languages, and the patient cannot understand the language of the notice and consent, the non-participating provider or facility must provide the qualified interpreter to meet the notice and consent requirements. So if it weren't difficult enough to get that notice and consent, well, it's even more difficult because you got to provide it in the appropriate language. For those of you in Idaho, where I happen to be today, those are the 15 most common languages in Idaho as of 2016. So what's the bottom line for this notice and consent option? If you want to go that route and try to get notice and consent and bill outside of the consent requirement or the cost sharing requirements, well, it's going to be difficult to do that. It's going to be difficult to satisfy the notice and consent requirements because first, that notice and consent exception only applies to very limited circumstances. Second, once you provide that notice to the patient, why in the world would the patient ever agree to allow you to charge them more than you are otherwise allowed to charge them under the statute? I suppose if they really like you and they want to come to you, then they may, but the government says, fine, if that's the case, then you got to make sure that they understand what the consequences are and that they're going to have to pay a lot more money or pay more money out of network rates than they would otherwise have to pay. That's the whole basis for all of this. In addition to providing that notice to the patient, you've also got to notify the insurer of certain information. The rules differ slightly depending upon whether you're trying to balance bill for the emergency services or whether you're balance billing for post-stabilizing services that are being provided. You have to maintain a copy of that notice and consent for 7 years. And so that kind of is a summary then of the balance billing requirements. In addition to all of that, the interim final rule imposes new notice of patient protections that you've got to provide to the patients in advance to make sure that the patients understand their rights concerning everything I just talked about. So who must provide a copy of this notice? Well, healthcare facilities must. Remember, healthcare facilities are the hospitals, critical access hospitals, ASCs, those entities. Also, providers who provide items or services at or in connection with a visit to a healthcare facility must also provide that notice so that they can, if they're not participating, so that they can satisfy the requirements. So the healthcare facilities have to provide their notice. Also, the providers who provide services in conjunction with a visit to a healthcare facility must also provide the notice. Who is not required to provide this notice or comply with these notice rules? Well, if the provider does not furnish items or services at or in connection with visits to a healthcare facility, if you don't work at the hospital or you don't provide services in conjunction with a hospital visit or an ASC or the like, then you don't need to worry about this. In addition, you don't have to give notice to patients who are not participants, beneficiaries, or enrollees in a health plan or health insurance. These rules don't apply to purely self-pay patients, so you don't have to give notice to them. You only have to give the notice to those insured patients. And you don't have to give notice to such patients if the items or services are not furnished at or in connection with a visit to a healthcare facility. Again, the surprise billing rules only apply to visits in conjunction with certain facilities. The type of notice you have to give 3 different types of notice. First, you've got to post a sign in your physical location, if you have a physical location. It has to be in a prominent location. The guidance specifically says that it should be, for example, where patients schedule, check in, or pay their bills so that they're going to see it. In addition to that, if you maintain a website, you've also got to post a copy of this notice of patient protections on the website, if you have one. That notice has to be, you have to include the required information on a searchable homepage or on a link that's easily accessible, not hidden away or tucked away someplace. The patient has to be able to access the information, that notice, without any charge or having to set up any kind of account or giving any kind of personal information. In addition to posting it, you've also got to give a copy of that notice to each patient who is going to receive or receives those items or services. And that has to be in the form of a 1-page double-sided notice using a font that's at least 12 point. You have to provide it in person, mail, or email as determined by the patient. They get to determine how they get that notice. It's got to be provided no later than the date and time when the provider or facility requests payment from the patient, or if the provider does not request payment from the patient, when the provider or facility submits the claim to the plan or the insurer. That notice must contain, in clear and understandable language, basically explain their rights under the no surprise billing rule. It's got to explain applicable state laws to the extent that they affect all of this. And it's got to contain contact information for the appropriate federal and state agency to report violations. Again, HHS is working on a model notice, so watch for that. That notice that you provide and post in your facility, that's also going to have to satisfy those language accessibility standards. If the provider is providing services at a facility, then the provider can enter into a written agreement with the facility so that the facility is responsible for providing that notice. In that situation, if the facility fails to provide the required notice, then that's not on the provider, but it doesn't allow the provider to go ahead and do the balance billing. Well, in addition to the foregoing, the balance billing rule also applies to air ambulances. The rule for air ambulances is pretty simple. If you are not participating air ambulance provider and you render services to a covered person, meaning that person has insurance benefits that are covered by or cover air ambulance services, then the provider may not bill the patient more than the cost sharing amount under the no surprise billing rule that would apply to a participating provider. There is no exception for notice and consent for air ambulance situations because I guess they figure that you simply, in most cases, can't get effective consent in advance in air ambulance cases. Of course, you may still bill and recover from the plan or the insurance for the covered services, and you may still bill self-pay patients. The new rule identifies or confirms that there will be a complaint process, so they can complainants may file the complaints with HHS for violations of the rule. HHS will review the complaint and may request additional information. They may refer complaints against payers to the CMS enforcement process or against providers under a separate process. Again, watch for additional guidance and rules. So that is an overview of what's coming down the pipe. So what do you guys need to do? Well, first, you need to consider whether you are in some of those states that have more restrictive state laws. To the extent you've got more restrictive state laws, you've got to comply with the more restrictive state laws, but also still comply with the no surprise billing rules to the extent there's not a conflict. The states, at last check, the states with the balanced billing protections that presumably would be affected are Arizona, Colorado, Delaware, Indiana, Iowa, Maine, Massachusetts, Minnesota, Mississippi, Missouri, New Mexico, North Carolina, Pennsylvania, Rhode Island, Texas, Vermont, and Washington. So you should, before January 1st, do the following: confirm and coordinate your state law requirements. For facilities, you should identify the non-participating providers who render services at the facilities, because those balance billing rules are going to apply to those non-participating providers, and it may trigger your notice requirements. For non-participating providers, you should identify situations in which you provide services at a facility and determine whether or not you are a participating provider at those facilities. If not, then these rules are going to apply to you. Prepare all of you need to prepare the notices of the patient protections if you are or render services at a healthcare facility. Remember, that includes, you got to post it on your website, you got to place a sign in a prominent location if you have a location. You've got that sign has to, or that, and in addition to that, you've got to provide that one-page notice to the patients. Watch for the HHS sample form on that. For providers, if you're going to make sure that the facility is responsible for providing that notice of the patient protections to the patients at the facility, then you're going to want to enter into a written agreement with those facilities so that they provide those notices on your behalf. You should determine if you are going to attempt the notice and consent from the patient. Just remember, it's going to be likely very difficult to obtain the patient consent. If you do decide that you're going to go for those notice and consents so that you can avoid the no surprise billing limits and balance bill a patient, then you're going to want to prepare the notice that you're going to have to give to the patient. Watch for that HHS form. You may have to tweak it a little bit, but HHS should be sending that form. You're going to have to prepare the consents for the patients or their personal representatives to sign. You're going to have to make sure that you put in place the process to notify the insurers that you did get that consent and that you are balance billing the patient. And you've got to make sure that all of those notices and consents are set up so that they accommodate the language barriers that may apply in your particular situation. You should educate staff and implement the necessary processes so that you can become compliant by January 1st, including the limits on the charges to patients and the balance billing rules, the amount that you can charge, that is how they go about distributing the one-page notice to patients, providing the notice and obtaining consent from the patients if you are going to try to fit in that exception, how you go about providing the notice to planner insurers if you do obtain that notice and consent and want to balance bill. Training probably should include your anybody at your facility or your group that is involved in payer contracting, the medical staff office, because they'll be involved in identifying who your non-participating providers are, patient intake and scheduling, billing and collections, compliance, website design, and others at your facility that may be implicated. Remember, the HHS is still working on the rules. This is an interim final rule. The government has requested comments to certain portions of these rules. Those comments are due September 7th. So if you really don't like this stuff or you have comments, then you can feel free to submit those comments back to CMS by September 7th. In addition, HHS is working on the forms that you're going to have to give out, so make sure you watch for those. So stay tuned for the additional guidance for HHS, because the additional guidance will be coming down in response to the comments. In addition, there are other aspects of the surprise billing rule or the No Surprises Act that will be coming down, things like the enforcement rule, the dispute resolution process, transparency and price comparison tools that are also covered by the Surprises Act. All right, that is it. If you need more information, then you're always welcome to reach out. If you have questions, feel free to reach out. We're still trying to work through some of this stuff. The government's thrown a lot at us. They have provided some answers. For other things, they told us to hold the line and they'll get back to us on it, but we'd be happy to answer questions to the extent we can. If you have additional information or have additional questions about this or other topics, you can always go to our website. We have a bunch of free articles and webinar recordings on various health law issues. That's just available for free through our website there. We appreciate your participation as always, and good luck in complying with these new rules.